Welcome, everyone. Sorry for the momentary delay in letting you all into the room. Before we get started our discussion on trademark infringement today, I did want to take a quick moment. I think we've got a number of new folks on the call that I wanted to just give you a quick 30 seconds to introduce yourself, your firm, and sort of where your focus is related to IP, patents, trademark, copyright, whatever that may be. So I'm going to go with the people that I think I know are new, and if I miss you, please just, you can use the raise hand feature, and I'm happy to do that. So Raffaello, is this your first meeting, Raffaello, in Italy?
Hello, my name is Raffaello, and I'm based in Milan. I am a partner of the IP and IT department of Gianni Oregoni law firm. I'm involved in trademark issues, patent issues, information technology and software issues, and so on.
Thanks, Raffaello. Christian, is this your first meeting with Beck Bruun?
Yes, it is. Hey, everybody. My name is Christian. I'm from the Danish law firm Beck Bruun, located in Copenhagen and second largest city of Denmark called Aarhus. My department, the IP and trademarks department, we do trademarks, designs, copyrights, marketing practices, and mostly litigation. So yeah, brief introduction.
Thank you, Christian. Julia.
Hi, everyone. I work with Marcela here. We are from Tozinho Freire Advogados in Brazil. We work in the practice of intellectual property and data protection as well. So nice to meet you all.
Great, thank you, Julia. And your colleague, Marcela.
Hi, guys. Can you hear me? I had this stupid screen that I'm trying to change. So I'm a partner here at Tozzini in charge of IP and Technology Information Department. Nice to meet you.
Great, thanks, Marcela. Do we have anyone else that this is their first meeting? By Xing, I think it is yours, but we'll hold off since you'll be speaking. Anyone else? Don't be shy. I know I've emailed with a number of you. So, okay, I'm going to go ahead and hand it over to Per, who is going to kick off the meeting on trademark infringements. And Per, for those of you who are new, I'll introduce very quickly. Per is the co-chair of the group for EMEA. Amalia, who we don't see her on video, but she is on the phone with Goodmans in Canada, is the Americas co-chair. And then, hi, Amalia. And then Jane Wang in Taiwan with Formosa is the co-chair for the Asia region for this group. So those are the chairs for those of you who are new. And with that, I will hand it over to Per.
Well, thank you, Hannah. Just very briefly, Per Lidman from Zettervalls, Sweden. The brief topic I'm going to talk about is actually just an introduction to Strat's presentation that will follow on the Adidas and the infringement issues recently decided. But let me now try then to share my screen, and it should show now. Can someone confirm?
We can see it, yes.
Very good.
Yeah,
so just very briefly, a little background on history on Adidas and the Three Stripe brand. The brand, or the company actually, or the man behind it, Adolf Dassler, he was supposed to have made his first own soccer shoes in 1920, roughly. And his dad had a weaving business that sort of inspired by this, he turned into a shoe factory where Adi, which was his nickname, you see where that is going, continued to develop his shoes. And his brother joined as the company's salesperson. And a little bit later than in 1937, the company's success actually had much to do with the growth, you can say, of the German military at this time. They produced shoes for them. But anyway, in 1937, they were making roughly 30 different model of shoes for different sports and for other uses then. But as you see on the right, this was the actual first logo of the company. And you can see the inspiration, of course, to what sports. But then came the three-stripe brand, and the background here is that the brothers, the Dassler brothers, they split. It's actually alleged that Adi told the Allied forces, now we're in the 40s, and he blamed his brother Rudolf for being connected to the Nazi company or the Nazi party, and Rudolf didn't like that, and they split the company. And the brother went on to form what is today Puma. So he continued and was quite successful also. But then Adi, and his combination of his nickname Adi and his last name Dassler, founded Adidas. And he, or Adidas, and he already from the start talked about this as the three-stripe company. But initially it could be just fun facts that these three stripes, they were added to the shoes, especially running shoes, as a support for wear and stability. But then when he wanted to differentiate his shoes, because his brother used the same designs, he started to use white leather for these support stripes. And hence the birth of the three-stripe mark in roughly 1949. And this has been a success, as we all know. Today, Adidas is one of the world's largest sports apparel manufacturers. I only found numbers from the 2012 or something, but then they were number 2. So, before we go on to the more interesting part that Strat is going to talk about, just as a backdrop, I just wanted to mention the status of the EU trademark registrations for the three-stripe brand. Because this was for many years thought to not have a specifically distinctive character or enough at least to be registered. But of course it was used extensively. So by that argument, in 2014, they managed to register this, and that is quite late if you think about the Adidas brand. But it didn't go so well on appeal because the registration was annulled in 2016, and that decision was appealed, and the EU court in 2019 confirmed the EU IPO decision, claiming that the trademark didn't have the distinctive character enough to qualify for a trademark registration. I think there is not many that will have the sort of guts to challenge the three-stripe brand today by saying it's invalid because of the acquired distinctiveness it might have in Europe. But anyway, another fun fact is that there is actually a mark prior to this, a Finnish one in the early 1940s by the company Karu. And it's supposed to be a true story that when this became a little bit of a conflict, Adi bought the brand from Kahu for 2 bottles of whiskey and the equivalent of what is today 1,600 euros. A good investment. But and some claim that this three-stripe brand, or rather the tilting version of it that we can see on some Adidas apparel, is supposed to symbolize a mountain, climbing which is an effort and so on, blah, blah, blah. And here I won't go through this, but these are just some examples of trademark disputes that have been going on, not only in Europe, but a number of these also in the US. But that leads us up to your presentation, really, Strat, and the most recent decision in the US. So I will stop sharing my screen.
Well, thank you. I don't have a fancy presentation, but what I do have is a copy of the complaint. Okay, so I'm going to share here. Make sure I pick the right one. Okay. Hello, everyone. Do you see my screen?
Yes, we see.
We do, but it's not, is it just a PDF? Because it's not in presentation mode, but we do see it.
Yeah, it's just a PDF. This is just the complaint.
Okay.
Yeah, so nothing fancy for me. Sorry, guys. So here we go. Along those same lines, Adidas has been very aggressive in policing its three-stripe mark, and it often goes after 2 stripes, 4 stripes, 5 stripes, just stripes in general. And one US high fashion designer, Tom Brown, he started selling about 10 years ago, started selling sportswear with 3 stripes. Whoa. And so Adidas obviously said, please stop. Maybe they didn't say please. And the Tom Brown then switched to 4 stripes. And as you see in the shared screen, those are the 4 stripes. Those are the clothes that Tom Brown designed and has sold for 10 years. Apparently Adidas and Brown were in negotiations since 2018, back and forth, and it just didn't pan out. So what happened after settlement discussions failed? Adidas sued Tom Brown in the Southern District of New York. The case was very fast, at least by US standards. It was filed in June 2021. Year and a half later, we have a jury decision. That is, just as an aside, anyone find themselves in the Southern District of New York in front of Judge Rakoff for a trademark case, he is going to go fast. And he will not listen to you to try to slow things down. That's it. He's going fast. And so it was in front of the jury, and they took, as an 8-day trial, the jury took 2 hours to come down with the verdict. And here is the verdict. I think you guys can see that. Pretty simple, doesn't give much information. Basically, not liable, boom, go home, Adidas. Except Adidas is not necessarily going home, because they just a week ago, they filed a notice of appeal. And so they're taking it up to the Second Circuit. That doesn't surprise me, but unfortunately, or I guess it's not unfortunate, but we don't have a nice 60-page decision to go through and discuss. Really, this is a jury. They sat through 8 days of testimony. Apparently, an associate of ours went to one of the days. Tom Brown dressed very nattily in a 4-stripe short suit with long socks. And on the verdict day, I think it was the entire Tom Brown team came in dressed similarly. And I think it's kind of funny that they all wore the 4 stripes throughout the trial, really rubbing it in Adidas's face. And the jury still took 2 hours to come back and say, no infringement. So takeaways. First off, what I see is it's hard to unring the bell. So 10 years ago, Adidas says, stop using 3 stripes. Tom Brown moved to 4, and Adidas said nothing. It's awfully hard to stop that after 10 years. And I think the jury was like, look, they had an opportunity. They didn't change. They didn't go after him. They let him sell for 10 years, and that's it. And so I think this was a bad case for Adidas from the start because the facts were bad. 2, it was a global fight, as Per said, showed in his presentation. The Adidas has been aggressive throughout the world to varying degrees of success. Europe, they have not been successful. In the US, they have strong rights for this 3-stripe design. But what did Tom Brown do after this lawsuit was initiated? They petitioned to cancel or invalidate over 20 of Adidas's registrations in the UK. And so, this is one thing I see a lot when I'm practicing is we have a fight in the US and we look, okay, what's going on elsewhere? Do we have registered rights in Europe? Can we add some pressure there in Europe or in the UK or in another marketplace? And so oftentimes these fights, while they're just a US fight, this was just a US fight, it expands immediately. And, it's all leverage. It's trying to resolve it, trying to get it done. It hasn't worked in the Tom Brown case. Adidas is continuing the fight. It'll be interesting to see what Adidas has to say, what their grounds for appeal are, because appeal courts are very hesitant to take a decision away from a jury. This is, that's it, period. There's got to be some very, very compelling errors to reverse that. And let's see, that's all I have. I don't think that, grand scheme of things, I don't think this changes Adidas' strategy. You still can't use 3 stripes in the US at least. Adidas will come after you. 4 stripes, hey, maybe that's an option now. 5, 6, 7, let's keep going. I think different color stripes as well. One thing I thought was funny, Tom Brown was talking about Adidas's 3 stripes, but really it's 5 stripes because you have the 2 dark stripes in between the light colored. And, so what is it that they own? Do they own 2 dark stripes, 3 light stripes? I think that Tom Brown did a good job, his lawyers did a good job at saying Adidas doesn't own all stripes. And that was their theme throughout the case, or at least in front of the jury. And it took jury 2 hours to say, you're right.
Excuse me, did you say that Tom Brown here, did they move on to try to invalidate some of Adidas registrations in the US?
Not well, so they did try to invalidate the registrations in the US, but that was, I don't think Rakoff, that decision came to summary judgment, and I think Rakoff granted that in October. Basically, the argument was that the designs are aesthetically functional, which it's a series of cases which is questionably relevant, or at least questionably, I'm not sure that it's an effective strategy to blow up trade dress. The Second Circuit has been inclined to do it before, but I don't really think it's a good argument. Not very, how do you measure aesthetic functionality? Because it looks good. If it identifies source, who cares? But I don't know, that's just my aside. That's an entirely different presentation.
Okay, thanks.
If I can just add a couple things from the Canadian standpoint, I admit I haven't done a deep dive into the Adidas litigation here in Canada, but back in the 70s, there was a case which focused on the functionality, of course, of the 3 stripes. And I guess, you know, much as what you were saying, Strat, how functionality can turn into distinctiveness over time. Fast forward to 2015, we had a couple of opposition cases here in Canada where Adidas went after a couple of marks before the trademarks office, and the federal court on appeal from the opposition board upheld the registrar's decision to refuse the oppositions, in this case, for again, stripe designs. And the basis here was that you have to be careful when you've got a famous mark, because it can be a double-edged edged sword, so that people are so familiar with a particular famous mark that, you know, if there's the differences, those can easily distinguish them in the mind.
I guess we lost Amalia, or is it just me?
I think we lost her.
Yeah.
Legal considerations.
Amalia, if you can hear us, your sound is coming across now and then. So
Yeah, sorry, can you hear me now? I'm unfortunately in transit.
yeah, now it's good. But we didn't hear you after you said be wary of famous marks, because if they're really famous, even small deviations can sort of work to make a distinction. After that, you
Yes, that's right.
broke off.
Yeah, and in this case, you know, the judge basically said, well, you know, you do have an enhanced scope of protection. They're so well known that you know, small differences may differentiate, and in that case, they were dissimilar enough. Like I said, that was a number of years ago, and I'd have to do a deeper dive, but you know, like most countries of the world, Adidas has certainly tried to protect its brands in Canada as well. I believe it went after Payless shoes at some point too.
They did, and they were less fortunate. They were ordered in the end to pay $64.4 million US. So
That's exactly right. You know, you're playing with fire if you start using 3 stripes on athletic apparel or footwear. It's, yeah, Adidas has one more than they've lost in the US at least.
yeah, but it raises a number of interesting issues around these. Let's call them simple marks or figurative marks, because the argument that Amalia voiced is actually one that I've heard also in Europe in various circumstances, that the sword could sort of swing back. Once you're really known, people will notice even smaller deviations, and of course that only applies, at least in my mind, to these simple figurative marks. If it's more complicated marks, you don't have the same situation, and also the copycat part of it will be more obvious if it's a more distinctive or complicated mark.
Yeah, I find that the argument actually compelling as well. It's like if it's such a simple mark and everyone knows the Apple, you know, let's go to the Apple device for Apple computers. Everyone knows that. But Apple's been very successful at stopping anyone from using fruit in connection with computers. Even though we all know that if we see an orange that doesn't have a bite out of it, it ain't an apple. But you know, I can definitely see that. You know, I think in the US it's tough because you also have dilution, and you know, which essentially just protects famous marks. and so they don't get you on infringement. Maybe they'll try to get you on dilution.
Does anyone from other jurisdictions than we've heard from now have any comments on similar or even Adidas issues in your home jurisdictions? Nope. Well, that's perfectly fine. But thank you, Strat. And we will watch with interest how this develops, of course. And it might be, if there is any substantial new sort of argumentation when the grounds are actually public, it might be an issue we could revisit.
Yeah, I'm happy to give an update. I'm keeping an eye on it. I have a docket reminder, tickler that when stuff hits, it comes to me, and so
yep.
I'll keep an eye on this.
Thank you.
Do you want to talk about Kanye West and Adidas too, Strat? That's a whole other story.
Yeah, I don't know much about that. I hope that in Adidas's contract it had a clear termination clause where it can get out whenever it wants.
Yeah. So, Hannah, would you guide us to the next item on the agenda?
I will indeed. Thank you again, Strat. That was really interesting. We look forward to hearing updates from you on that case. So next we have Baixing from Zhonglun, who is going to talk about some findings in recent, I think it was 3 retrials, right, with a client of yours regarding trademark infringement.
Okay, thank you. Can you hear me?
Thanks, Baixing. We can.
Okay, today I will introduce the case we called Baisen case. Baisen, the company name is similar to my name, so I think it's interesting. The case is my introduction include 3 parts. The first one is background. The second the key issues, and the third part is some key findings. The background is some basic information about the cases. There are 3 cases. 4 are patent infringement cases, and the right holder, the patentee, is Shunxin. We call Shunxin company, and the defendant is our client. The client is Baisen company. There are 3 asserted patents in the 3 cases. In China, we normally 1 patent, 1 case. I mean, if you will file a action against a lawsuit against the defendant, normally you can claim only 1 patent in 1 case. So there are 3 asserted patents. There are 3 cases. The patent and the accused product is related to cardboard folding device. The 3 patents all are related to this device. There are 3 procedures. The first one is the first instance infringement case. The 3 cases were handled by Ningbo Intermediate People's Court for their first instance. And our client, Baisun, lost 2 cases. In one case, our client win the case, but in another 2 cases, our client lost the case, and the court ordered the client Baisun to stop infringement action and to pay 250,000 China yuan for damages. After the first instance judgment, the client engaged the Zhonglun law firm to represent the client in the appellate procedure. In China, for your information, in China, all the patent infringement cases should be handled by the Supreme People's Court. But the cases should be handled by IP Court of the Supreme People's Court. So in China, in the Supreme People's Court, there are 2 divisions or departments handling IP cases. The first one is the IP Court of the Supreme People's Court. Maybe we also call the IP division of the Supreme People's Court. The second one is the third tribunal, third civil tribunal of the Supreme People's Court. The IP Court of the Supreme People's Court mainly handle the appellate cases, especially for patent infringement cases. So in the second instance, we reversed the 2 judgments in which our client lost. So we also win the third case. Our client didn't lost the first instance court, first instance judgment. So we win all the 3 cases in the second instance. After the second instance judgment, the patentee, the opponent, filed a retrial application before the Supreme People's Court. As I mentioned before, the third civil tribunal of the Supreme People's Court will handle the retrial cases. During the retrial procedure, one of the asserted patent was invalidated. So for this patent, for this case, the Supreme People's Court rejected the opposing party's request for retrial. And another 2 cases were heard by the Supreme People's Court. The at the end, the Supreme People's Court rejected the patentee's request for retrial. So we finally win all three cases. It's the background. So we will move forward to the key issues. There are three key issues. The first one is claim construction. The claim one of the asserted patent 1, 2, 3, we called it's 1, 2, 3 number 1, 2, 3 patent. The key limitation or technical feature is the device has 4 limit posts, and then the limit post has an inclined acute angle at its end. And the first issue is that we have different claim construction about this specific technical feature. We argue that not the end of the limit post of the accused product does not have an acute angle as said by the claim, and then the patentee asserts that the acute angle is clerical error when drafting the claims. So the issue is whether the judge should consider this limitation or when determining the protection scope, whether the argument of clerical error should be accepted. It's the first issue. Then the second issue is regarding doctrine of equivalence. We argued the end of the limit post of the accused product has not have an inclined acute angle. Just see the picture in the slide. And then the accused product does not need to reduce the damage to the HA of the cardboard by forming an inclined acute angle. So we mean the effect and the function also are different from the acute angle in the claim. So we have different opinion about the function and the effect of the accused product's structure. It's the second issue. The third issue is how the Supreme People's Court handle the retrial cases. Whether the Supreme People's Court will have on-site court hearing or just handle the retrial cases by online hearing or by documentary trial. It's also interesting in China. It's a procedure issue. So we have three findings for the three issues. The first one regarding the claim construction. The second instance judgment emphasized all the features stated in the claims are limitations of the protection scope of the patent right. When judging whether the accused product falls within the protection scope, the court should consider all the limitations, including the acute angle in the claim. So please note, in China, we have some judicial interpretations because the patent law is not so detailed. So the Supreme People's Court issued some judicial interpretations regarding the patent infringement cases. As showed in the slide, one of the judicial interpretation emphasized all the limitation or technical features should be considered when determining the protection scope. Even if the patentee's argument is right, and there is a clerical error, the limitation also should be considered when determining the protection scope. The second finding is not how the Supreme People's Court determine the doctrine of equivalence. The key finding is not in China we have judicial interpretation emphasize not equivalent features should mean features which use basically identical means to achieve basically identical functions and attain basically identical effects. And also for the person skilled in the art, it's not a creative efforts. So for this case, the second instance judgment hold that the means of the technical feature of the accused product are not basically identical to those of the asserted patent and could not achieve the function and the effect of the Chamberlain buffer and preventing the edge A from being damaged by the limiting post. Actually, in the invalidation procedure, we filed the invalidation petition against the patent, asserted patent. And during the invalidation procedure, the patentee claimed the acute angle have special technical effect. So we use this statement during the invalidation procedure. So the court accept our argument. The third finding is not in China, especially in pandemic period. The court normally will use online hearing to handle retrial cases. In this case, the court held 2 oral online hearings for the retrial procedure. So it's also interesting. It's my introduction. Thank you. Hi, Hannah.
Thank you, Baixing. Does anybody have any questions for Baixing?
Yeah, this is Jane. I am curious about two things. The first thing is that you mentioned there is online pre-trial hearing. Is this something regular, or is it just because of the like COVID, or so is this a regular procedure to go online hearings? And the second question is that you mentioned the invalidation procedure, right? So does the IP division of your Supreme Court reviews the patent validity issue in an infringement case? So that's two questions I have.
Okay, thank you. First, before the pandemic, the Supreme People seldom held online hearing, but after, I think in the future, online hearing will become regular. I think because it's convenient, especially for parties in other province. I mean, different from Beijing. Second, in China, infringement cases, the court will consider invalidation documents, but in infringement cases, the court will not directly decide invalidation or patentability issues. But for some very obvious invalidation reasons or grounds, the judge will consider it, especially if the technical feature is too weak to decide its protection scope. The judge may refuse to protect your patent, but the cases are not so many. Thank you.
Thank you.
Well,
Any other
very
questions from anyone?
interesting. Thank you. I would say interesting. The question Jane posed about the sort of connection or non-connection between the validity and the infringement proceedings was also one that I had, and in just a reflection that in Europe, at least, I would say that in a very large number of all patent infringement cases, one of the defenses is to launch an invalidation action against the patent. And typically in Sweden, they will be handled together. They are formally two different cases, but they will be handled together and by the same court and at the same main proceedings, which sort of makes it possible for the court to consider invalidity claims also in the infringement issue. But it's very informative. Thank you.
Yes, in China, normally the defendant will file invalidation request against the asserted patent before CNIPA during the infringement cases, during the infringement procedure. Normally, the invalidation will be made. Invalidation decision will be made during the infringement cases. So the defendant can use the statement, the claim construction during the invalidation procedure to defend themselves.
But what would happen then if that parallel invalidation procedure arrives at the decision that the patent is invalid totally, or that the major claims are invalid? Wouldn't that be a sort of a hindrance for the continued infringement process?
If the patent is invalidated, especially the asserted claims are invalidated, the court normally will dismiss the infringement case, and the patentee could file administrative litigation against the invalidation decision before the court. If the patent survive or revive after litigation, means the patentee could file a new lawsuit.
Okay. Yeah, sounds like a lawyer's heaven. Yeah.
Yes, some normally you will have some cases.
Yeah. Okay. Thank you very much. Anyone else have questions for Zheng? No. Then Hannah, did you have any other ideas for us for the last couple of minutes of the session, or are we done?
Well, I had not working on here if we had time, which we usually need about 10 to 15 minutes for. So I think we can skip on that. However, does anybody have, we always do a call for topics or speakers, or if you're working on an interesting case that we can talk about at our next meeting. Does anybody have anything that they want to raise their hands for?
Well, if you don't right now, just feel free to email Hannah afterwards. And also for clarity, this goes the other way around. That is, if you see something happening in a jurisdiction other than your own, which seems interesting, you could sort of file that question. Is there a possibility for someone in the group to present on this issue? That is also a possibility. So. Please feed
Absolutely.
us with topics.
And don't be surprised if we reach out to you. So, you know how we ended up with Stratton by Xing today. I found a couple of articles that were posted on our website or posted on LinkedIn, and I reached out to them. So don't be surprised if one day we also reach out to you because we find something interesting that you or a colleague has written about. But please don't be shy about emailing us, any of the leaders or myself, if you are interested in speaking, or if you see something that you're interested in hearing about from one of our members. I'm happy to do the legwork and get the right people involved in the call. But with that, I wanted to thank Strat by Xing pair for presenting today. We will post this recording and the materials that were shared from all of the speakers on the website, and everyone have a great afternoon, evening, whatever time it is for you there today.